attendees wanting to know if maybe Robert, you want to start, and then Orlando, in the brief time we have. One of our attendees wondering in your thoughts on using Beauregard type claim language for AI patents. Is that a good practice or should it be avoided?
This is Robert. I mean, sure. For those who don't know, Beauregard claims come from a case of that name in Ray Beauregard, and they're basically a way of claiming programs stored on a medium. So I often include those types of claims. How valuable they're going to be will depend on how the invention ends up being commercialized. You know, is it sold by selling copies of it? In which case, every copy is an infringement of the Beauregard claim. You know, these days, very often, software isn't sold like in the old days. It was on CDs or discs or something. So, you know, often those claims are not as valuable as the claims involving the execution of a method because software is so often available as a service now.
Orlando, your thoughts?
Basically, in the examples that I gave you of how functional limitations come out in a system claim for AI, one of those patents has basically a Beauregard claim. You know, something that causes the processor to do this, or instructions or code that causes the processor to do that. That's a classic Beauregard claim, and that's in that granted patent, and it hasn't been tested yet. But so they're useful if you can find another way around. You're going to end up in functional limitations anyway. So